Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we are doing a flagship series titled India's Top Litigators, and we have one of India's top litigators as our guest today, Senior Advocate Mukul Rohatgi. Now, for the past many decades, you have seen him all over the media, in the Supreme Court every day. Also, many leading cases that you who are watching all yourselves know. But let me give a formal introduction. As we all know, he has served as the Attorney General of India. And some of the biggest corporate battles and commercial cases of corporate India, we have seen him arguing for the biggest clients in the Supreme Court of India. Most recently, also, there was a bit of Bollywood that he did. Of course, he's been doing many cases. The most recent was the Aryan Khan case, which was a bail matter and one of the most high profile matters for which, if I'm not wrong, Mr. Rothi flew down from London to argue the matter. And of course, but that is not what he does mainly. Mainly is all top corporate commercial work that he does in Delhi at the Supreme Court, and that is going to be the core and focus of our discussion today. Good to see you, and looking forward to an interesting half an hour. Uh, so, at the outset, we will speak about what you're doing currently because there is so much you're doing. If you could just share with us the top 4 5 cases that you remember in the past 10, 12 years that are worth mentioning and that were challenging for you also.
See, the most important case affecting the Indian judiciary was the NJAC case, or as it is popularly called, the judges' case. A new constitutional amendment was brought in by the new government came in the year 2014. The amendments were challenged, and that was the first big case in which I appeared as the Attorney General. The second big case I remember was the aftermath of the coal policy case which the Supreme Court had annulled before I took over and before the new government came. But what was the way forward after annulling the policy and annulling all permissions and letters of intent was a huge task for the government as to what should happen in the new regime. It was soon followed by what is called the triple talaq case, in which a challenge was laid to the practice of triple talaq. And I was also fortunate enough to have taken part in that case. And as I remember, soon after that was the singular case in which the Supreme Court had a painful duty to convict a sitting judge of a high court for gross contempt of the Supreme Court. I had to assist the court in that case, and unfortunately the contemner showed no remorse, and the sitting judge was sentenced to 6 months in jail. That was a very unfortunate kind of a case. Thereafter came the challenge to the Aadhaar policy. I was there in that case midway. The issue was right to privacy. Is it there in the Constitution or not? The petitioners were arguing that it is there, and I had submitted initially that there is no right to privacy in the Indian Constitution. And I showed the Supreme Court a judgment of 8 judges, or 6 judges, I'm not sure, which had said so. And the matter was then referred to 7 judges. It's at that stage that I gave up that case because I relinquished office as the Attorney General. So those were some highlights of the Attorney General's tenure from 2014 to 2017. If you remember, we were then struck by COVID in 2020, and the courts were only on Zoom. And one of the major cases I remember was the case which dealt with the PMLA. That case is called Vijay Madan Lal. That was a 3-judge case, bench case. It was preceded by a case called Nikesh Tarachand, in which the Supreme Court struck down the 2 stiff conditions engrafted in Section 45 relating to bails. And because of those conditions, it is well now impossible to get bail. We were very happy that they were struck down, but they have been clumsily sought to be brought back, which I don't think is legally correct. And that issue is now left for a later debate. And then, as I told you, it was Vijay Madan Lal's case. And then there have been several cases. I have not.
But one thing that everybody says about you, and a lot of people remember, that the current Prime Minister of India, Narendra Modi, when he was Gujarat Chief Minister, you have defended him. You have defended the current Home Minister Amit Shah when he was also in Gujarat. And that too, and your list doesn't end because you've defended Bhupesh Baghel. You have also defended, so you have defended politicians of all colors. You have not limited yourself. Could you also share that? Because you are liked by politicians across parties. It's not as if it's one party or one dispensation.
I will tell you, but just let me finish in the last question.
Yes.
A major case before a constitution bench in the trying times of COVID, which was argued on Zoom without, papers, etc., physically available, over a large record of thousands of pages, was what was called famously the Maratha reservation case, in which the Maratha reservation was struck down by the Supreme Court. Now, going back to the cases of politicians that you mentioned, soon after I became the Additional Solicitor General in the year 1999 under the Vajpayee government, Gujarat had riots in the year, if I'm not mistaken, 2002, soon after Mr. Modi had come to power as the chief minister in that state. And a large number of those cases in the form of PILs were brought before the Supreme Court, alleging that the state government, including its head and its functionaries, were complicit in the riots, that either they egged on the riots or they looked the other way, etc., were the allegations of the PIL groups. And I had the chance to appear for the state government and its functionaries, bureaucrats and politicians, including the names that you have mentioned, to defend them in the Supreme Court. Those were very trying times. The court was hostile. And I was a young ASG at that time. I'm talking about more than 25 years ago. And those cases went on from 2002 till about, if I'm not mistaken, 2009, 2010. And I look back happily that I could defend the government and its functionaries with whatever was at my command. And finally, those cases ended, And there has been no blot, I repeat, no blot on the state government or its leaders, its main leaders, as to whether they were that they were complicit. No such finding has been recorded. And in fact, I may tell you, Tarun, the last of those cases filed by the wife of late Mr. Jaffrey, who was an MP who was killed by the mob, ended in the Supreme Court only about 2 to 3 years ago, where the Supreme Court dismissed the petition and refused to issue any notice or call upon Mr. Modi to reply to the allegations, because the whole prayer in that case was that Mr. Modi should reply to the allegations in that case as if he was complicit. And that case was rejected by a very detailed judgment running into at least, if I'm not mistaken, about 200 odd pages. And I think that was the lid on that too. And that gave me a great feeling of satisfaction. But as you said, I have actually appeared for politicians across the spectrum, whether it is of
Yes.
BJP, whether it is of Congress, whether it is of TDP, whether it is of, you see, the Andhra government party of Mr. Jagan Reddy. I used to appear for late Jayalalitha, for AIDMK. I'm doing a large number of cases for the DMK government. I am appearing for a large number of MPs, MLAs of the DMK government and many other governments. I have also appeared in a large number of criminal cases. And I must tell you, I started in life as a civil lawyer doing property, intellectual property, and other kinds of cases. But in the last few years, I willy-nilly also donned the hat of being a criminal lawyer. I do a large number of criminal cases, whether it is for bail or for conviction or for things like murder and so on and so forth. And, so that's how so you know it's all
One
the
thing I want
hues
to
on the canvas.
One thing I want to ask you, you have represented DK Shivkumar, Jagan Mohan Reddy, All India AIDMK, which is that party in Tamil Nadu, Ida Party Palaniswamy, Karedi Water dispute also, Dilip Ray, Bhupesh Baghel. I'm just speaking politicians, B.S. Yedurappa, Kamal Nath, Gowda. I mean, the list is endless. For a large number of people, many times certain advocates become party advocates, just appearing for one party. Do you think the true hallmark of India's top leading councils is that across parties for your legal acumen, they tend to trust you that it is Mr. Mukul Rogi that should represent us. He should argue our matter. Could you also delve on that issue?
See, if you are typified as a party lawyer, then obviously you appear for only that party, whether it is the petitioner or the respondent. But if you are a true professional, then your services should be available to all and sundry, whether it is people who are targeted as criminals, whether it is industrialists, whether it is intellectual property cases, whether it is politically motivated cases. If you are a professional, everybody should be able to come to you. And if I may say humbly, that if different types of hues come to you, different people from different walks of life, then it is clear that you are acting as a professional and that people of opposite views in the sense of opposite parties, etc., have a feeling of confidence that they will not be betrayed in as much as the lawyer concerned will do his best, whether he appears, let's say, for AIDMK on day one and DMK on day two. That should not make a difference. In the, in fact, in the symbol case between AIDMK internally, between Mr. Palaniswamy and the other gentleman, I appeared in that case also before the Election Commission also. I have recently appeared in the Election Commission on behalf of the NCP, and we succeeded in showing that it is the Ajit Pawar group which is the real NCP and not Mr. Sharad Pawar, notwithstanding that he may have been the founder, etc. I also appeared for the Eknath Shinde group and so on and so forth. So the basic idea is that the client should have the confidence that his case will be represented to the best of the ability of the lawyer, notwithstanding whichever hue or whichever thinking the person may have.
You have also, in a sense, a unique distinction that in dozens, the top leaders of corporate India trust you with arguing their matters in Supreme Court over the years. If you could go back a little bit, one of the biggest corporate battles that India ever saw of inheritance was the Ambani brothers, and you had a role there. But you have also represented Tatas. You've also represented the who's from Godrej to Tatas to Mahindra to Adani to RPG Group, Apollo Hospitals, Daiichi. The list is endless.
See, Tarun, the point is a lawyer who has a wide spectrum of cases, is like a marketplace. Everybody is free to come to the marketplace, and the client or the customer must have confidence. And the names that you have mentioned, I have appeared for the large industrialists, mid-level industrialists, small entrepreneurs, shopkeepers, traders, markets, agriculture market committees, municipal corporations, Zilla Parishads, banks, public sectors, state governments. I mean, I can go on and on, but that's not the idea. So the first major battle, as you mentioned, was between the two Ambani brothers. And that started in the Bombay High Court, ended in the Supreme Court. I was fortunate to have been representing one side of that battle. But it is important to note that though I appeared for Mr. Anil Ambani in that battle, that has not stopped me from appearing for Mr. Mukesh Ambani's companies, in as much as I remember appearing for Mr. Mukesh Ambani's family when somebody had questioned as to whether they should get Z plus security, etc. One of those motivated PILs. So I have appeared for all these industrialists. And in fact, if I may tell you, it has been several occasions that, let's say, have been appearing for Z in many cases. But at the same time, I may be appearing against Z. Or take Tatas, I may be appearing for one Tata company in favor of Tatas, and I may be appearing against another Tata company at the same time. Because, it can't be that you've appeared for one Tata company, then you can never appear against the Tata company, unless you have a retainer not to appear, etc. So, it is possible at the same time in two different cases. One is appearing for that client, one is appearing against that person. And therefore, if the client has confidence, then these things also happen. Because I deal with hundreds and thousands of cases. It is impossible to keep a record that at one time you are appearing for say, one company of Tatas, and on the same day it is possible in next court you may be appearing against another Tata company, etc. So it
In fact,
and that happens only because of confidence.
in the business of media also, you have a large imprint. I was researching, I found out that most recently you appeared for Subhash Chandra of the Z Group. You also appeared for Star and Sony. So, as in sector, also you have covered a lot. In every sector, you have an imprint. What is this also a requirement of India's top litigator that across sectors you should have an imprint? You should not be a lawyer for builders or a lawyer for mining guys. It should be across sectors.
Tarun, I never wanted to remain typified in one particular type of litigation. You see, as you say, some people are known as builders' lawyers, some people are known as employers' lawyers, some are known as employees' lawyers, some are known as landlord lawyers, some are known as tenant lawyers, and so on and so forth. I never wanted to do that, and I was lucky to have started in the Delhi High Court, which is one of the premier high courts in the country. I'm proud to say that I started in that high court, and I still love going back to that high court, whatever time is available to me from the Supreme Court. And our high court is a young high court, having been formed in 1966. It has excellent quality of judges, including a large number of young judges who I must say very proudly sit, you see, even beyond 4:30 p.m. in court time so that they can finish cases because they have a very heavy board. And so in that high court, there was, myriad types of cases which I could attend to. And I had the good fortune of having started in the chambers of late Shri Y.K. Sabharwal, who rose to be the Chief Justice of India. And he gave me a lot of opportunity to appear in different types of cases right from day one. And, that envelope kept kind of expanding. And that's how it happened.
One thing I would want to know, except for the Ambani brothers case, the Aryan Khan case, I mean, you've done much bigger cases, but because it is media and Bollywood, everyone discusses. In fact, lot of youngsters, when they see your photo, they say is Aryan Khan's lawyer. Lot of young kids, and I have myself witnessed it. I know you appear in the Supreme Court largely. Very, you go to other forums rarely. High courts, of course, when you go for a full day to other but you came down from London and appeared in a lower court, the district court level for this case. Uh, is that a challenge for someone, for you? I mean, because you are in Supreme Court, so to go there and argue, is it a challenge?
No, 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 let me correct you, Tarun. I didn't go to the lower court, I went to the Bombay High Court.
Right.
But it was a challenge for me. It was still the COVID period. The period had not ended. I was on a vacation in London
Yeah.
when I got a call from Mr. Shah Rukh Khan requesting me to come to London, requesting me to come to Bombay to argue that case because his son was in jail. I was initially reluctant to come because coming for one case and then trying to go back to London, I thought my vacation would be completely truncated. And COVID was another reason, so I was completely disinclined. So as luck would have it, he said that can he speak to my wife? So I said sure. And my wife was right beside me. So he somehow convinced my wife that I should go because it was his son's case, etc., etc. So then I traveled to Bombay, and I was there for 3-4 days. And fortunately for us, the learned judge was a very hardworking judge, a young judge, and he did not keep the matter pending for more than 2 or 3 days. He heard the matter for about 2 hours total, and there and then, he made up his mind and granted bail. He did not reserve the order because he knew that reserving the order means another 10-15 days would have gone by and the incarceration would have continued. So he granted bail. Uh, and I must tell you, I returned the same night, late night, by a British Airways flight back to London, having successfully done that case. See, it was not a big case. It was a bail case. I mean, I do this day in and day out. It became big because it was a cynosure of all eyes. I was getting messages and calls all through those 3 days, and about 10,000 calls and messages after the case as if it was the greatest bail case because a lot of people were looking at it internationally, nationally, etc. So that's how the hype was. And it's all because of you guys in the media.
One thing I want to ask you, I was looking at your exposure in the steel sector and I was amazed to find out the world's largest steel making company is ArcelorMittal. You have done a lot of cases for them. But there are smaller companies like Jindal's JSPL and JSW, which are bigger in India, but in the global scale, they are not as big. So your exposure even in the metal sector is immense. Could you share any anecdote about ArcelorMittal that you
Yeah,
appeared?
now let me tell you, this is also a very unique story. Now, I have been I've been the lawyer for the SR group of Ruyas for the
Yes,
last about 40 years.
they are
I
also
have
steel makers.
Yeah, I have been doing their cases for the last 40 years when I used to travel to Bombay and stay in their guest houses in Bombay in those days. Now, they have been my clients and very good acquaintances and all that. So, in the fight for takeover of the steel factory of SR at Hazira, Gujarat, it was ArcelorMittal that I was fighting because ArcelorMittal was the successful resolution applicant in taking over this company for about 50,000 odd crores. And we were fighting ArcelorMittal. And in fact, just to tell you as a footnote, that I pointed out that there was a legal provision that if ArcelorMittal's directors were directors of another company which owed money to the government, then they could take over SR only if they paid those dues. That company paid the dues. So Mr. Mittal himself, I think, was a director in some other companies and which had dues to the government. And therefore, he had to pay about 8,000 crores extra. And he told me after the case that you have made me pay 8,000 crores extra and became, an expensive deal and all that. But once the deal was done, in the last 5 years, steel has gone through the roof. So it's been Mr. Mittal who has been laughing all the way to the bank, not the other way. And the curious part is that in the last 3 odd years that I've started appearing for ArcelorMittal, I have been appearing for that company in Gujarat High Court, in the Supreme Court, in the Delhi High Court, the large number of litigation. So it only shows that the client must have comfort in approaching a lawyer who may have been against them in some of the litigation. That's proof of this fact.
One thing I saw even the hospital sectors, you have a large imprint. You've appeared for Apollo Hospitals, one of India's leading hospitals and globally well known, but also many other hospital chains. Could you also share some anecdotes on the exposure to hospital and arguing for these people?
See, I have been appearing for hospitals and doctors associations, medical colleges, individual doctors, surgeons, in large number of negligence cases, uh, but I have never appeared against the doctors. I feel that they are doing a great good to society. Mostly, they are hardworking. They have studied a lot, and I personally feel that their earnings are not commensurate to what they are doing. They're saving lives. I think which is far more important than winning a case, saving lives, and so are the hospitals. So I've never appeared against them. I always appear for them, whether it's individual lawyers or hospital cases for negligence or colleges, etc., etc. And let you in on a small secret, which is that my father used to tell me that ultimately it is the medical profession, the doctors and the hospitals that you will require in advancing age. So always keep them on your right side. So, I have never ever appeared against doctors, as I said. And I know a large number of doctors who are running great institutions, right down from Dr. Rehan of Vedanta, Dr. Reddy and his daughters of Apollo, whether it's Fortis, whether it is Mr. The people who run Manipal, the Pai family, etc., etc. So that's the secret. They told me never appear again.
One that is a good note that you shared with the viewers. One thing I want to know in the aviation sector, one of our last questions. I again saw that you have a large imprint. You appeared for everyone from Indigo to SpiceJet, and could you also share some anecdotes on your exposure to the aviation sector?
See, the cases of the aviation sector are relatively younger because all these private airlines have grown up in the last maybe 15 or 18 or 20 odd years. So, yes, I've appeared for, in the old days, I used to appear for Air India.
Air
When,
India.
when Air India was a government corporation, I did a large number of cases for Air India because there was perennial litigation by the employees, whether it was the pilots guild, whether it was the air hostesses group, whether it was ground crew, whether it was various bodies and employees, and they would constantly be fighting Air India. So I did a large number of those cases. Then came along Indigo and SpiceJet and so on and so forth. And let me also tell you, it's a matter of coincidence that SpiceJet and Indigo are kind of rivals in one sense, but the owners of both the airlines, as well as myself, come from the same school. So not that there is a connection that way, but that is only a coincidence. Both of them are obviously much younger to me in school, but that's how the aviation sector has been. I also used to appear for Jet, and in fact, I have conducted some cases recently wherein Jet is being sought to be revived by Jalan Calrock,
Yeah.
Calrock combined, where Mr. Jalan is from Dubai. We are trying that. Also, I am also doing cases on behalf of lenders of Go Airlines, where Go has now gone bankrupt, and the lenders want some of the lenders have lent engines. So they want their engines back. Somebody wants the body of the plane back. All that is also going on.
Two sorts of companies that you appeared a lot for. A lot of mining companies you've done cases for where the financial stakes, including taxation, run into thousands of crores. Do you think it's a big challenge to do those kind of cases because revenue to the state is involved?
Yes, so a large number of cases where revenue is involved in favor of the state, you are kind of on a back foot because the courts generally lean in favor of government or sovereign dues. And as you rightly say, mining involves large revenues. So it is a challenge, but you take the challenge in your stride, whether it's a constitutional challenge or a fiscal challenge. I've appeared for very large mining companies. I remember whether it is Jindal, a lot of them are South Indian companies like MSPL. I remember a big company and many other leaseholders. But yes, those stakes are heavy because a large number of those leases in the old days were given to families, not necessarily, big industrial groups. So these families had to uh, deal with these issues. And those laws are rather tricky because there is an involvement of the central law vis-a-vis the state law. So the rules are by the state because, as you know, mining of major minerals is under the center. It is under the center, but the major work is done by the state. The state recommends and the center has to concur. So there is, sometimes a conflict between the state and the center. And the mining laws underwent a very drastic amendment that no mining leases will be given on first come, first served basis as it used to be, till there was a challenge in the coal mining cases. And after 2015, they cannot be given, on a first come, first. This is, it can only be by auction. And those auctions have fetched, according to me, not less than a few lakh crores for the government in the last 8 years.
Now, two sectors where you have opened a sort of a new practice. These days, lawyers practice till the age of 95. Recently, we see two lawyers who passed away. They were arguing in court and Supreme Court till the age of 95. And as years change, clients also change. You have also diversified your practice. I saw you doing online gaming matters across courts. And this is a new industry which you took up. Can you share your experience? Because this industry, as we foresee, will have a lot of litigation in the next 15, 20 years. Do you see this as a large part of your practice?
It's not a large part of my practice, but yes, this segment, as you just mentioned, has huge stakes wherein the amounts of revenue are staggering. Now, these online gaming cases are a kind of a changeover from the traditional games. You know, the traditional game, let's say, was Rummy. Rummy was played in a club or a house across the table with 11 cards or whatever. Now, that in the new regime has now become a game which you can play on the net. Two people who are strangers are brought together by a platform. The platform may be Dream 11, maybe somebody else. They charge only 50 rupees for bringing two people together as their commission. And the two people play against each other and they're complete strangers. So that can be done from anywhere in the world, etc. So the name I mentioned, Dream 11 and some others, their turnover is in billions of dollars. Billions, not millions, market billions. Because it's become a favorite pastime with let's say, a population of India, which is more than a billion. A large section is willing to play, let's say from the age of 16, 17 till the age of 75. You can imagine how many people are trying their luck. 2, 300 million, 400 million people. And so it's a gargantuan amount and task. And the government is now trying to say that the GST should be levied not only on the income of the platform, which was 50 rupees, but on the whole kitty, which we think is not correct. So that is one part of the GST issue, which is now in the Supreme Court, where the amounts are more than 50,000 crores. The other part, which I must tell you is equally important, for which I have appeared in the Madras High Court, in the High Court in Karnataka, in Kerala, and in the Supreme Court. And we have won in all those states till now. And namely, that issue is that the state governments were saying that playing online rummy amounts to gambling. We have argued it is not gambling, it is a game of skill. Gambling predominantly is a teen patti game, as we understand, where you just bet on the strength of your cards. Except, you can play blind on some bad cards, whatever. But rummy is not a gambling, but it's a game of skill. And there are Supreme Court precedents to say that rummy is a game of skill. And the state governments brought in new amendments in the last 5 years, labeling rummy and poker played on the screen as gambling and therefore prohibited. There was a prohibition. Those prohibitions were challenged by these companies, and the challenge was successful in all the southern states. And the prohibition imposed was struck down, and the state governments have gone to the Supreme Court. But Supreme Court has not yet ruled upon that issue, and therefore that game is still continuing. So that is my brush with the gaming sector. But let me tell you that I don't play rummy or whatever, either traditionally or on the screen.
One thing I want to also say, you also have diversified your practice. One thing we are seeing, 10,000 crores are being invested in India by funds of Singapore, UK, US to buy roads in India. These roads are finished roads. They toll the roads for 30 years and maintain it. So tolling and building in a poor country like India, there is no other way. How do you build infrastructure? And in the past 10 years also, we saw contracts saying UP 22,000 crores worth of PPP model road contract was given to two large contractors. In every state, we see this. And we see primarily a lot of people file PILs and try to, stop the connection. And this affects investment in India because primarily roads are being built and people are invested in taking over those roads. Do you see this as a large part of your practice, and do you think the state should honor the commitment made to the private contractors?
See,
To
there are two issues here. As you rightly say, that for infrastructure, huge funds are required. The NHAI itself cannot provide the funds, so it's a public partnership model, and the large part of the cost is recovered through a toll over 25 years, etc. So one has to calculate a full projection as to how much money will be involved, how much money will come back, and then you decide. It's a very, very complex and a tricky process. But I must say, by and large, NHAI has been more forthright and more investor friendly than many other government agencies and government bodies. That is one. But there is large amount of litigation between NHAI and the road developer, which ultimately goes to arbitrations where huge claims are either granted or refused, which ultimately go up to the Supreme Court. That is one major chunk of this litigation. The second, as you mentioned, are generally frivolous PILs in different high courts relating to different sections of road. Let's say from Delhi to Karnal or Karnal to Chandigarh or whatever. And those PILs are motivated by personal stress that look, I have a shop on the highway, so let not there be a toll right in front of me because it's going to affect my business. So you cook up some case and say, oh, remove the toll. Or if some road is being widened, it's going to take away some part of your land or your factory. Then a PIL is initiated that the route should be realigned, route should be changed, things like that. Or somebody doesn't want to pay toll at all. So he says, no, you shift the toll. So these kind of PILs, unfortunately, have been entertained by different high courts. The Supreme Court has soundly said they don't entertain these things because they are a drag on the development of the nation. And but these kind of things do arise, and then they are ultimately squashed. But I must say that in the last 10 years of this government, I have seen as a lawyer that the amount spent on infrastructure and its development in the form of roads and bridges has been exceptional. And you can see it for yourself. If you drive from Delhi, I often drive to my hill house near Nainital. So you see the road from Delhi going up to Muradabad, Rampur, then Haldwani and all that is becoming better and better. So the incentive is not to go by train or by anything else. You take off in your car early in the morning and you whiz through most part of the roads. And I mean, that's what I've seen, whether you go to Jaipur, Chandigarh, go to Ajmer. And in fact, my desire is to drive from Delhi to Bombay when the Bombay highway will be commissioned, I think, by the end of this year. So it's one thing which is like a showcase for modern India.
one last question to you is, you have reinvented yourself every 10 years. You said you started off as a civil lawyer, you ventured into criminal law also, you've done bail matters, you've done PMLA, you've done corporate financial crime matters. Of late, infrastructure and gaming is also a significant new industry that you have taken up, given the. So, if you were to practice till like the three greats who are a generation older, K.K. Venugopal, Ram Jethmalani, Fali Nariman. If you were to practice till the age of 95, do you think you're open to taking up new areas and new kinds of cases in the next 10, 12, 15 years of your practice?
I don't know whether I lived in 95 or 85, but I think it is important to keep your body and mind functional and agile. And therefore, you have to change with the times. Before COVID, I did not know how to operate a laptop at all. I didn't even know how to put it on. Now I can operate a laptop, not maybe as professionally as you can because you are much younger, but I can still kind of make my way through a laptop. I can read mails, I can send mails, I can do corrections, I can be on iPad and also try to learn to argue a case from the iPad by having a bookmarked SFP. I didn't know what was a bookmarked appeal, but now I know what it is. And Chief Justice of India insists that in his court, people should only argue in paperless fashion. So I try to do that. But some of my friends are far more professional about it than I am. But yes, the idea is variety is the spice of life. How can a lawyer say that I will not move with the times? So to move with the times, he has to do all kinds of cases. The latest flavor, I must tell you, is the IBC cases, the
Yes.
bankruptcy. That was a line which no lawyer had seen till this law came a few years ago. So now we have learned what the law is and how drastic the law is. And now one of the major changes are the criminal acts which have come in place of the IPC, CRPC, etc. So one will have to learn that. So no good saying this is 302 or 376 or 377 or 420. Now all the new sections will have to be rattoed like what is ratto. So we'll have to do all that. But yes, the idea is to move with the times and remain agile.
So there's never a dull moment in the field of law, as they say. And we appreciate that you joined us, shared all your experience, cases, and so many people will benefit when they watch you. Promoters, GCs, people who are in litigation, lawyers also, so many of them. We wait until now, a year's time. Next year, we again request for your interview on India's leading
So
litigators. And I know there'll be a bunch of new and very important cases that you will share with us then, which you will do this year. But until then, goodbye and thank you so much for coming. Thank you.
thank you.